Okay, this was from eviction court. It got continued. I'm looking for the date. The update, it's not there. Okay, I asked for a jury trial. It was granted. The jury demand filed, no fee paid, granted, allowed. Now it's a non-jury trial. I just got a email from the lawyer doing this to me that they had the jury trial, but I didn't show up or something. I didn't get. I can't see, couldn't see it too good. But we wouldn't have gone through this months of foolery if the judge had granted me my right to be heard. The right to be heard, often referred to by its Latin maximus audiere ultimum, however, heard the other side, is a fundamental legal principle ensuring that no individual is penalized or judged without a fair opportunity to present their case, evidence, and arguments in court. In the United States, the right is the cornerstone of due process, is protected by the 5th, 14th Amendments to the Constitution. It guarantees that effective parties receive proper notice of legal proceedings and a meaningful chance to defend themselves. In practical terms, the right ensures that you are informed, you have the right to know the charges or claims brought against you. You can present a defense, you can submit evidence, testify on your own behalf, and call witnesses. Judges remain impartial. Judges are legally bound, allowed to everyone legal interest in the proceedings, and their attorneys the right to speak. Crime victims can participate. Victim also had the right to address the court through victim impact statements during the process. All right, so she denied me my right to be heard when I first stepped in front of her. I talked to the lawyer before that, and I held no secrets that I filed for an appearance. He knew that. He said it would cost me money. I said I filed a fee waiver. And he said, well, the judge ain't going to do this or do that. I says, well, I filed for a jury trial. I said, well, she's not going to grant it. I says, well, I filed it. I filed a fee waiver. And she's not going to grant the fee waiver. I says, well, we'll see. I mean, it's my right. And he said he would just talk to the judge and see to it that I can't get my evidence, in the courtroom, because he knew all the, everything about here that need to repair it. My argument was first with the landlord, and I think he got upset because I told him about, discovery, discovery law, discovery clause, and it's in legal term and uh, and realty. So when he bought the building, the people he bought the building were supposed to notify him what had to be repaired, and they were supposed to set up a schedule. And this is called disclosure law. And in disclosure law, they're supposed to set up a schedule and make all these repairs. Well, they didn't make the schedule. They didn't disclose this to anybody. Nobody's doing anything. We got rust flowing through the water. You run the hot water, steam builds up from the shower. There's no windows, just a small vent that doesn't take anything out, and the steam turns orange on the walls. So I got to clean the walls at least once every 2 weeks, and sometimes it comes out, pretty different colors in the faucets in the bathroom. And every now and then black stuff comes out. And there was multiple leaks in the ceilings, in the bathroom, the kitchen, a couple in the front room. And the landlord thought painting the kitchen ceiling was enough to cover up all the water spots. In the bathroom, they had to replace the ceiling because it was falling. And all kinds of cracks and bubbles, and but they didn't do anything about the black mold. They didn't do anything. The guy that was out here when the last landlord owned the building said the same thing landlord said before that the building's old. You gotta understand the building's old. Oh, I says, I understand it. Okay. Now, according to the law, all these repairs have to be made. And they said, no, I said, look it up. It's on the internet. Landlord fixes everything. There's electrical damage. The plumbing has to be replaced. They were the ones that told me I have to understand the building's old, the plumbing's old, and how much it'll cost to replace the plumbing, ingoing, outgoing. So they were asking me to live with it, but at the same time raising the rent. I says, no, we'll talk about raising the rent after you make these mandatory repairs. You're legally supposed to do this. I says, didn't your lawyer talk to you about this? Your advisor, your counsel, they're supposed to advise you about this. I says, you're literally breaking the law. Didn't they? So this last one, I think his lawyer didn't tell him about it, and now he knows about it. So first they're taking me to eviction court, saying I didn't pay the rent. I proved I paid the rent. Now they're saying they raised the rent, and I refused to pay that, but they didn't say why, and it's because they don't want to pay for these mandatory repairs. And I'm leaving here anyways. I'm doing my best to get out, but now I can't get out because these people said because of the eviction notice, settle that, and you can leave. I mean, we'll help you. You can come in, but so now I'm going to have this eviction notice on me. But anyways, I wanted to tell the judge this was legal harassment. This was a retaliatory measure because I was demanding that they do what they're legally supposed to do. The last landlady didn't do anything, and she got mad. She threatened me with eviction because I wouldn't pay the increase. I said, after you do these mandatory repairs. I asked her, did you speak with your counsel? Did they advise you? She said, what? And I said, yeah, you're a lawyer. They're supposed to legally advise you. This isn't a disclosure law. You're supposed to make all these repairs. I came here to make money. I didn't come here to spend money. And she even told me another time, this is what they do. They buy a building, they keep it for a couple of years. They raise the rent, keep it for a couple of years, sell it. Buy another building, raise the rent, keep it for a couple of years, and sell it. And basically don't do any repairs. Okay, so the right to be heard. Okay, so we're going to go to the Code of Judicial Conduct. Okay, so I'm pretty sure you heard of that. Okay. Ethical standard behavior of judges. Okay, so they took the oath to do this, okay? We're going to use a model rule because it's bigger and easier to read, and every state uses it. Okay, so the right to be heard is over here, Canon 2. Ensuring the right to be heard. And the judge told me no. She wanted to put me in an early resolution program, team me up with some lawyers so they can tell me just to do what the judge wants. And the lawyer said that he was going to talk to the judge, and the judge is going to do what he wants. So I don't know how that works out between them, but a judge should accord every person has a legal interest in proceeding with the person's lawyer the right to be heard according to law. Okay, so she denied me that. All right. And where is it? So anyways, I wanted to disclose, well, she ex parte communications according to a lawyer. See, so I wanted her to respond to the lawyer's misconduct. Okay. A judge having knowledge that another judge has committed a violation of the code raises substantial question regarding the judge's honesty, trustworthiness, or fitness as a judge. Other respects shall inform the appropriate authorities. And I informed that judge the only reason I'm in there, and that I went through this before, is because I told her I was in this court before, and I says, and the judge told him to remove the eviction notice so I could move. the wrongful eviction, and he didn't, and that's how I wound up here, because I had to pay 4 months security deposit because that lawyer didn't remove the eviction. That was contempt of court. The only reason they were evicting me is because I was moving, and they didn't want me to move. They wanted more money and for me to fix more things there. Okay, so I was trying to relay this to the judge. A judge having knowledge that the lawyer has committed a violation of the rules of professional conduct to raise a substantial question regarding the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate authority. A judge who receives information indicating a substantial likelihood another judge has committed a violation of the code shall take appropriate action. A judge who receives information containing a substantial likelihood that the lawyer has committed a violation of the rules of professional conduct can take appropriate action. So that's what I wanted to report to the judge, the lawyer's misconduct. He was violating the rules of professional conduct, but because his guaranteed ex parte communication that there was no way, no how she was going to allow me to get this on the record, you know, so that should disqualify her. You know, decorum, demeanor, communication with jurors, responsibility. Sure. So okay. So I mean, it would be competent, diligent. See, if she would have gave me the right to be heard, the judge shall perform judicial administrative duties competently and diligently. A judge shall cooperate with other judges and court officials in the administration of business. But see, a judge shall perform judicial duties, and these are judicial duties, and one is ensuring my right to be heard. She was showing bias for that lawyer. She talked to him, and I had to shut the hell up and wait till they were done talking. Judge shall perform the duties, including administrative duties, without bias or prejudice. Judge shall not perform as a judicial by words, conduct, manifest bias or prejudice, or engage in harassment, including but not limited to bias, prejudice, harassment based upon race, sex, gender, religion, national origin, ethnicity, disability, age, sex orientation, marital status, socioeconomic status, political affiliation, and shall not permit court staff, court officials, or other subjects to the judge's discretion or control to do so. A judge shall require lawyer in proceedings before the court to refrain from manifesting bias or prejudice. Impartiality and fairness. How is she being impartiality and fair when she's not being competent and ensuring my right to be heard? Wow, talk about massive violations. Okay, so she wasn't being impartial or fair, so you could just click that open. And judge shall uphold and apply the law and shall perform all duties judicial office fairly and impartially. And she's not doing that, crazy ass woman. Giving precedence to the duties of judicial officers. She's not doing that. The duties of judicial officers prescribed by law shall take precedence over all judges' personal and extrajudicial activities. And I'm talking about that ex parte communication that lawyer was talking about. Okay, so automatically you gotta go to Canon 1, because that shit didn't happen either. A judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. 11.1, competence with compliance with the law. That didn't happen. A judge shall comply with the law, including the Code of Judicial Conduct. What the hell, judge? But this is common in so people, I keep telling you, you need the rules of the codes, you know. Promoting confidence in the judiciary. A judge shall act in all times in a manner that promotes public confidence and in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. If there was cameras in the court and everybody knew the rules in the court, everybody would be watching it, and we'd put electric collars on them, so that way everybody, throws $1 in so you could buzz in where they get electric shock. And enough people, Just saying, like the Running Man, except for it's like with judges and lawyers instead of people. Okay, so Canon 2 automatically invites Canon judge will conduct personal and extra duties to minimize risk of conflict with obligations of the office. Okay, a judge shall conduct the judge's personal and extrajudicial activities to minimize risk of. Okay, so extrajudicial activities in general, like no ex parte communication, but that always happens. A judge may engage in extrajudicial activities except prohibited by law. Participate in activities will interfere with the proper performance of the judge's judicial duties. Participate in activities that will lead to frequent disqualification of the judge. Participate in activities that will appear reasonable person to undermine the judge's independence, integrity, or impartiality. Engage in conduct that would appear reasonable to a person to be coercive, or use the court's premises, staff, stationery, equipment, or other resources except for incidental use activities that concerns the law, the legal system, the administration of justice. Okay. Appearance before government bodies, testifying as a character witness, use of non-public information, appointments to fiduciary. Oh, judge for candidate, but okay, so violated Canon 2 basically in its entirety, okay, simply by, not, granting not granting, but ensuring the right to be heard, making sure I had to be right to heard, because she knew he told her that I wanted to, report him for violating 2.5 lawyer misconduct. Okay, so then you go to the preamble and use that against them, and there's a whole lot of stuff. So you want to pile this on top of it, okay? Right there. 3 paragraphs. They didn't do that, okay? And you could use the scope as well, as further wording in your complaint. But see, this is pretty common in any court. Okay, so now we're going to go to the rules of professional conduct. We're going to use Bar Association again because the printing is bigger. Okay, preamble and scope. We're going to go over the whole thing because it says what a lawyer should do. A lawyer is a member of the legal profession, is a representative of clients, an officer of the legal system, and public citizen having special responsibilities for the quality of justice. As a representative of clients, a lawyer performs various functions as advisor. A lawyer provides the client with informed understanding of the client's legal rights and obligations, explains their practical implications. An advocate, a lawyer, zealously asserts the client's position on the rules of adversary system. A negotiator, lawyer, seeks results advantageous to the client, but consistent with the requirements of honest dealings with others. As an evaluator, a lawyer acts by examining a client's legal affairs and reporting about them to their clients and others. I even told the last landlord and this landlord about the rules of professional conduct. And so read that. If you're, ignorance of the law is no excuse. Your lawyer can use that against you. Well, you hired me. You should have known. But no, they don't talk about this. They don't. I had lawyers get mad at me, walk away from me, threaten me for bringing this up in front of their clients in public. In addition to these representative functions, a lawyer may serve as a third-party, neutral, non-representative role, helps parties to resolve disputes, other matters such as rules directly lawyers have to serve with third party. Okay, we'll get past that. Now, all professional functions, a lawyer should be competent, prompt, diligent. A lawyer shall maintain communication with a client concerning the representation. A Lawyers should keep in confidence information relating to representation of a client so far as to disclose required and permitted by the rule of professional conduct or other law. See, these are laws. It says or other law. So that there tells you these are laws. Lawyer conduct should conform to the requirements of the law, both in professional service to clients and the lawyer's business and personal affairs. A lawyer should use the law's procedure for legitimate purposes and not to harass or intimidate others. A lawyer should demonstrate respect for the legal form and those who serve it, including judges, other lawyers, and public officials, while a lawyer's duty, when necessary, to challenge rectitude of official actions, also a lawyer's duty to uphold the legal process, in which he isn't. As a public citizen, a lawyer should seek empowerment of the law, access to the legal system, which they're putting roadblocks from me everywhere just to keep this evidence of, the administration of justice and the quality of service rendered to the legal process. As a member of the learned profession, a lawyer should cultivate knowledge of the law beyond its use for clients, employ that knowledge and reform the law, and work to strengthen legal education. In addition, a lawyer should further the public's understanding of the confidence in the rule of law. And the rule of law, he just totally threw that out. The rule of law means, everybody's equal under the eye. No, to him, I'm not an equal. In justice system, he's taking advantage of my ignorance of the law. Justice system, because the legal institutions and the Constitution of democracy depend on the popular participation and support to maintain their authority. All lawyers should be mindful of deficiencies in the administration of justice and the fact that the poor and sometimes person who are not poor cannot afford adequate legal assistance. Therefore, all lawyers should devote professional time and resources to use civil influence to ensure equal access to our systems of justice for all those who, because of economic or social barriers, cannot afford secure adequate legal counsel. A lawyer should aid the legal profession in pursuing these objectives and should help the bar regulate itself in the public interest, in your interest, folks. Okay, and they don't do that. Otherwise, nobody would be violating the rules of professional conduct and the code of judicial conduct on a daily basis in every court of law. Many of a lawyer's professional responsibilities prescribed in the rules of professional conduct as well as substantive procedural law. However, a lawyer is also guided by personal conscience and the appropriation of professional peers. Lawyers should strive to attain the highest level of skills to improve the law and legal process and to exemplify legal profession's ideals of public service. Remember that video I did? All public services are legal required to do what's in the public interest. All lawyers' responsibilities as a representative of clients and officer in the legal system and a public citizen are usually harmonious. Thus, when opposing party is well represented, a lawyer can be a zealous advocate on behalf of client, at the same time assume that justice is being done. So also the lawyer can be sure that preserving clients' confidence ordinarily serves the public interest because people are more likely to seek legal advice and therefore heed their legal obligations when known communications will be private. In the nature of the practice, however, conflicting responsibilities are encountered. Virtually all difficult ethical problems arise from the conflict between lawyers' responsibility to clients and the legal system and to the lawyer's own interest in remaining an ethical person while earning a satisfactory living. The rules of professional conduct often prescribe terms resolving such conflicts. Within the framework of these rules, however, many difficult issues of professional conduct can arise. Such issues must be resolved through exercise and sensitive professional and moral judgment guided by basic principles underlying the rules. These principles include a lawyer's obligation zealously to protect and pursue a client's legitimate interest within the bounds of the law while maintaining a professional, courteous, and civil attitude towards all persons involved in the legal system. The legal profession is self-governing, although the profession also has been granted powers of self-government. Legal profession is unique in respect to the close relationship between the profession and process of government and law enforcement. This connection is manifested in the fact that ultimate authority over legal profession is vested largely in the courts. To the extent that lawyers meet legal obligations of professional calling, the occasion for government regulation is obviated. Such regulations also help maintain legal profession independent from government domination. An independent legal profession is an important force in preserving government under law, for abuse of legal authority is more regularly challenged by a profession whose members are not dependent on the government the right to practice law. The legal profession's relative autonomy carries with it special responsibilities of self-government. The profession has a responsibility to ensure that its regulations are conceived in the public interest and not in further interest or parochial interest or self-interest concerns of the bar. Every lawyer is responsible for observance of the rules of professional conduct. A lawyer should also, in securing aid and observance by other lawyers, neglect of these responsibilities compromises the independence of the profession and the public interest which it serves. Lawyers play a vital role in the preservation of society. The role requires an understanding of lawyers, their relationship to our legal system. The rules of professional conduct, when properly applied, serve to define that relationship. Scope. The rules of professional conduct are rules of reason. They should be interpreted with reference to the purpose of legal representation and the law itself. Some of these rules are imperative. Cast in attempt self shall not define proper conduct for purpose of professional discipline. Others generally cast in term may or may not be permissive. Okay, people, so you can go through this. It's not that long, because I want to get to the rules themselves. The rules purpose, a large-scale context, shaping lawyers' role. The context includes court rules, statutes relating. Okay, so we're going to go to the rules. So preamble and the scope, competence. Okay. Lawyers shall provide competent representation of client. Competent representation requires legal knowledge, skill, thoroughness, and reasonably necessary for representation. Okay, diligence. The lawyer shall act with reasonable diligence and promptness in representing a case. Okay, so diligence, communications. People always complain about that. A lawyer shall promptly inform a client of any decision or circumstances with respect to which the client's informed consent. Okay, promptly inform the client of any decision or circumstance with respect to which the client's informed consent is defined in Rule 1.0 is required in these rules. So I told you, informer's consent is required before any proceedings can move forward. Reasonably consult with client about all the means by which the client's objectives are to be accomplished. Keep the clients reasonably informed about the status of a matter. Promptly comply with reasonable requests for information. And consult with the client about relevant information on a lawyer's conduct when the lawyer knows the client expects assistance not permitted in the rules of professional conduct. A lawyer shall explain the matter to the extent reasonable necessary to permit the client to make informed decisions. So I'm mentioning that because as this lawyer that took me to, suing me, he's changing everything up from evicting me to suing me, and I got the way the court procedure is going on. Okay, so I know the client had to talk to his lawyer, and I even talked to that lawyer about the previous landlord and how she was still sending me notices for the rent, emails, and so I know he talked to her because I told her she pulled the same stuff he's pulling, and even she backed down, and I'm surprised he talked to me because her lawyer she never gave me her lawyer's number, and the landlord before that never gave me their lawyer's number because I wanted to do what they were legally required to do. So the building kept changing hands, and everybody was avoiding their legal obligations. And who told them to sell the building before they get caught up in paying for all this stuff? Conflict of interest, former judge, third party, organized, declining or terminating representation. So, he could terminate his client's representation because his client wanted him to pursue this because it's nothing but legal harassment. I told him, We can settle this issue about the rent increase after they do the mandatory repairs. And with one landlord, I took their word for it, and I signed it. And she did that just to sell the building. And so when a new landlord took over, I tried to talk to her about it, and she was really, really upset. I guess she talked to her lawyer. She was really mean. But I kept telling her I wanted to talk to her lawyer. Representing a client, a lawyer shall exercise independent professional judgment and render candid advice. And rendering advice, a lawyer shall refer not only to the law, but to other considerations such as moral, economic, social, and political factors that may be relevant to a client's situation. And considering the fact that I'm a handicapped senior over 65 years old, in a wheelchair, and the landlord told him, he even yelled at me, I got it on video, you think you get special treatment because you're handicapped? I never asked for any special treatment for my handicap status. All I asked to do what they were legally responsible to do and make sure I have clean water, habitable living conditions. I understand the plumbing's old and has to be replaced. I understand that. So let's just get it done. A lawyer shall not bring and defend a proceeding, assert, convert issue therein unless there is a basis of law or fact for doing so. It is not frivolous, which includes a good faith argument for extension, modification, reversal, or extension. A lawyer for the defendant in criminal proceedings or respondent in the proceedings that could result in incarceration may nevertheless so defend the proceedings as to require that every element of the case be established. Okay, so he has no meritorious claims or contentions outside of the fact that I refuse to pay the increase. That's the only issue they have there. I refuse to pay the increase, but they didn't state why. So that would require candor towards the tribunal. A lawyer shall not knowingly make false statements or fact of law to the tribunal or fail to correct a false statement or material fact law previously made by the tribunal or by the lawyer. Failure to disclose to the tribunal legal authority and controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by the opposing party counsel. Offer evidence the lawyer knows to be false. If a lawyer, the lawyer's client, or a witness called by a lawyer has offered material evidence the lawyer knows that known as false is falsified, the lawyer shall take reasonable remedies, including necessary to disclose to the tribunal. A lawyer may refuse to offer evidence other than testimony of the defendant in a criminal matter the lawyer reasonably believes is false. A lawyer who represents a client in an adjudicative proceedings who knows that a person intends to is engaging or has engaged in criminal fraudulent conduct related to the proceedings shall take reasonable remedy measures, including, if necessary, disclose to the tribunal. Okay, nobody wants to do what they're legally required to do. The Clean Water Act specifically says that I get clean water. The landlord's supposed to make that. And it's not just me, they're evicting other people for wanting the same thing, to make the repairs. The electricity's faulty, it's old. Saying the building is old doesn't fix it, doesn't make anything better. You have to understand the building's old, the plumbing's old, the electricity's old. The law doesn't say, well, it's old, so we're not going to fix nothing, we're not going to update anything, we're not going to upgrade anything to, present day standards. No, that doesn't work for me, because it's old. An ex parte proceedings in lawyer shall inform the tribunal of all material facts known to the lawyer that will enable the tribunal to make an informed decision whether or not facts are adverse. So there's no impartiality. Fairness to the opposing party. A lawyer shall not unlawfully obstruct another party access to evidence or unlawfully alter, destroy, or conceal a document or other material having potential evidentiary value. A lawyer shall not counsel, assist another person in doing any such acts. So did he tell his lawyer, the lawyer, did he tell his client, hey, you're legally supposed to fix all this stuff, you know, I'm sorry I didn't tell you before you bought the building, but I got to tell you now, you know. So their argument was between each other, and when the landlord was yelling at me, telling me, no, it's not him, it's the other owners, it was their problem that they didn't fix it. My argument was, I said, no, when you bought the building, you bought the problems. Look it up in disclosure law. It's on the internet. Check your phone. You got your phone? So I started recording him. Since I recorded him, he don't come back no more. That's when he was yelling at me, telling me I think I'm special or need special care because I'm handicapped. In pretrial procedure, make a frivolous discovery request or fail to make reasonable, diligent effort to comply with legal, proper discovery request by the opposing party. In a trial, allude to any matter of fact the lawyer does not reason to believe is relevant and will not be supported by admissible evidence. Okay, so there's no fairness to the opposing party, and the judge doesn't like it because I don't have counsel. Truthfulness in statements to others. Of course, a represented client shall not knowingly make a false statement on material fact of law to a third person, fail to disclose material fact to the third person when disclosure is necessary to avoid assisting a criminal fraudulent act by a client unless disclosure is prohibited by 1.6. And he kept talking over me because I kept talking about, disclosure. Did you just, was this disclosure law requires, that they do all this stuff, that when they bought the building, the people that sold it to them were supposed to let them know about everything that they didn't fix that was supposed to be fixed. And they were supposed to set a schedule to fix it, but they didn't do that. So, so it's, and they try to disacknowledge my security deposit, but they know I have receipts, so they're trying to work their way into keeping it. The last landlord told me she wasn't going to give it to me. She had no record of it, and then she found record of it, and then I needed to give her a record of it if I had record of it. And I said, you already gave me a record of it, so I don't need to give it to you. Dealings with unrepresented person. Dealing on behalf of a client with a person who is not represented by counsel, lawyer shall not state or imply that the lawyer is disinterested when the lawyer knows or reasonably know that the unrepresented unmistakably that the lawyer's role in the matter. Lawyers shall make reasonable efforts to correct a misunderstanding. And he tried to correct me by saying he doesn't have to abide by the rules. Because, when I say diligence, candid toward tribunal, these are all laws in the rules of professional conduct. And he just kept talking over me, laughing, and okay, so he's involved with a law firm, so they're in this too. They're not hard to understand if you just open them. Had this kid opening them. I told him to open this and read it. Reporting professional misconduct. And you're surprised that he understood it. A lawyer who knows that another lawyer has committed violation of the rules of professional conduct raises a substantial question. Okay, so I'm not a lawyer, but I wanted to use my, right to be heard to the judge to expose all this misconduct. But the judge denied me my right to be heard because then she would have had to gone over the rules of professional conduct and reported that misconduct, because reporting misconduct is mandatory. a lawyer who knows, another lawyer has, a lawyer who knows that a judge has committed a violation of the Code of Judicial Conduct has to report it. A lawyer who knows another lawyer has reported, violated rule of professional conduct has to report it. They don't even have to be involved in the same court case. They could be watching it on TV, yeah. Oh, they just broke the law, and they took the oath, and the oath requires them to do all this, and they're not doing it. Like this kid had a criminal case years ago. And there was no probable cause. Refraining from prosecuting a charge that a prosecutor knows is not supported by probable cause. But the state's attorney sat back and laughed because it was the public defender trying to get this kid just to sign a piece of paper and leave with a felony. So I talked to the kid. He said, what about a probable cause hearing? There's no probable cause, and the public defender judge ain't going to like that. So they held his case for last, and the judge was mad, yelling at him. Well, I know you want a probable cause hearing. I will have one right now. I know where this is going. This is going to trial. So I told the kid, I told you, the assumption of guilt starts from when you were arrested. The presumption of innocence doesn't exist. The judge is mad because he's got to sit out here and talk to you because you didn't walk out of here with a felony like that public defender wanted you to. So it wound up going to Cook County, and then that public defender tried talking him into taking the plea deal. He didn't say it was a plea deal. Just take this. The judge is upset. Just sign this. Get out of here. The judge is really mad at me because, you're still here. You didn't sign this. You should have done it before. He's mad that other judge is mad that you just didn't take this felony and go home. But he didn't say that directly, but basically that's what happened. So they spent like almost a year trying to convince this kid. They even offered him a motion to quash, but he didn't take it. He said, no, Judge, I just want the lawyer to do his job. I said, no, you're supposed to tell the judge, Your Honor, cite my attorney for ineffective assistance of counsel, reporting ineffective, reporting violations of the rule of professional conduct and the Code of Judicial Conduct is mandatory in the rule of professional conduct and the Code of Judicial Conduct. Any lawyer or judge knowing of any violations in the rules or the codes, it's mandatory for them to report them to appropriate authorities, and then start going over the rules that your lawyer violated. And that's the judge's job to do so. But the judge didn't do it. And they all know this is supposed to happen from the very beginning, but nobody does this. Refrain from prosecuting a charge that the prosecutor knows is not supported. But they eventually threw out the case because the kid said no. Either we go to trial, and he asked for a jury trial, and he told me he wanted to pick his own jury, or you just let me go. So they dropped the case. Make reasonable efforts to ensure that the accused has been advised of his right to procedures for obtaining counsel, has been given a reasonable opportunity. You know what? Nobody advised him of his right to a quick and speedy trial. And they should have thrown that out. I had him read this yesterday. And he was shocked. Now, this is supposed to be your right, constitutional right, but it ain't happen if you don't demand it. This is deprivation of rights. This is not happening. Illinois speedy trial law mandates that a defendant in custody be brought to trial within 120 days of arrest, while those out on bail or recognizance must be tried within 160 days of filing a formal written demand. Otherwise, the case gets dropped, y'all. They're supposed to throw it out. And he was surprised he understood it. I said, you know what? It's just because you never read it. You let some lawyer explain it to you. I said, now, I'm showing this to you, so all I need you to do is open your mind, open your eyes, and it'll open your mind. You're a lot smarter than you think. And then I had him read this. I had him read that other stuff, too. He was in shock. Illinois speedy trial mandates, okay, with trial within 100 days of arrest or 160 days if you're out on bond. In custody limit, the state must commence trial within 100 days of taking the defendant into custody. Time is paused if delays are caused by the defendant, continuance of fitness or examinations. And why they always exceed that, because people don't, they have a hard time convincing them just to take the cop out. Yeah, we don't have probable cause. We can't prove nothing. So if you take this cop out, it's going to look like we did our job and we're tough on criminals here. But how is that being tough on criminals? It's a waiting game. The war of attrition. I've seen a lot of people sit behind bars for like 2 years, and then the state's attorney come and say, listen, and the public defender, listen, you take the plea deal, you sign these papers, you can be out tomorrow, you could be out next week. You already did the time. And people actually do that. But if they knew that the state's attorney, the public defender, and the judge exceeded their right to a quick and speedy trial, damn, that's deprivation of rights. Everybody gets charged with deprivation of rights. That's a conspiracy against rights under the color of law. Consequences. If prosecutors fail to bring the case to trial within these limits and delay wasn't the defendant's fault, charges may be dismissed or the defendant released from custody, bail. Constitutional right. The right is also protected by the U.S. Constitution, Illinois Constitution. All the Constitution tests evaluate factors like length of delay, reason, and prejudice to the defendant. So he left thinking pretty hard. I mean, come on, people. It's not that hard to prove a conspiracy against rights under the color of law. I didn't even throw any evidence at you yet. And here it is. Not me, you. Because you got to read it. If you read all this, it's easy to prove a conspiracy against rights under the color of law. Okay. But it started out with my right to be heard being denied. In the more laws I throw at, then they just throw up all these roadblocks to keep me from getting it on the record. So this is kind of like my ex parte. The lawyer told me that he was going to talk to the judge, and this was before I even appeared in court. And so I knew what was going to happen. This judge was going to do everything and anything to keep me. I have videos. I did a video yesterday showing how the water looked. Well, I'm going to show you how the water looked. But it's ridiculous. It's ridiculous. A guy yelling at me, you think you need special treatment?
You deny everything. You feel like you're obligated treatment, special treatment.
Every time I try to talk, he just starts talking over me. This is when they replaced the toilet. That was February 3rd. And I waited forever on that. And look at this, because bolts were rusted. The toilet wobbled. Black mold. I had to clean black mold around under it, constantly. Not every day, but it would build up, and that was after they fixed the leaky faucet, but you see the water left orange stains on the tub. And you could see the discoloration that was from bleach, and around that surrounding that's black mold. I constantly had to be spraying for black mold growing out of the faucet. Okay, so here's a sink. They replaced it December 24th, and here's before he replaced it.
When you turn on the one on the left, that water will come out fast. Force it a little bit. Rub in the cherry. Oh, okay. Seeing that black stuff keeps coming out.
But this one will shut the water? No.
Oh, that one? No, that one I have no problem with. That one just never completely shut off. And it gets real humid in here, so I had to shut off the water. I can't use the hot water without it getting... So, why don't you take all this stuff out of there? Get it out of your way. I'm sorry. I was up earlier, and I was throwing up, and I meant to get that out of there.
It'd be nice to us.
See, and it turns the sink orange, the water. Did you notice?
Yeah, I can see that.
Yeah.
As soon as we change the faucet, it will be fine. I mean...
Yeah, the guy changed the faucet in the bathtub a couple years ago. He was supposed to come back and change this, but he never did. And he was complaining about the water usage. And I said, well, I told you after I first moved in, and nothing was done. And so that's all I wanted, you know.
All right.
Oh, yeah, and look up there from the water leaks upstairs. I was telling her about that. The first one, it was just up there, above the shower. This was the second one, and that was the third one.
All right, I'll take pictures of it. This
Okay.
way the plumber can go upstairs above you exactly, you know, to manage what's going on there, like figure
Okay,
out.
you should see, I took some videos. There was orange water everywhere, on the floor, up here, in the sink, on the toilets. I came to use the bathroom, and
Yes, I'm gonna need a bucket because it's not stopped.
See, and that was December 2024. And they just did the ceiling and just replaced the toilet. So after, what, 2.5 years? There's some other videos in here of I think this one when the water was
came in to use the bathroom, and there was water all over the place. On the sink. I don't know why it's orange. Dirt there. Water on the floor. Under the toilet. On the toilet seat. I just ran this water and the black stuff came out. It had to be good. Doesn't shut off. Not all I can do is shut off the hot water. This will get annoying. Gets worse all the time. Complained about it a couple of years ago. The only faucet we replaced was the one in the bathtub. He's working on it over the weekend, but he's getting it. Came in. Water's constantly running. Actually, it was running a little faster. It's off. Watch when it goes coming out black and gray. Something's happening with the hot water. You can see the water leaves rust stains around the bottom of the sink. I clean that every week. See these gray stains? That's when they had the hot water off for a while, or the water off. And when they turned it on, all this black stuff came flying out. Come to the bathroom. The faucet usually leaks twice as fast as hot water. They replaced the faucet in the tub a couple of years ago because it was leaking. I said, great, change the one in the sink because it leaks too. But they didn't do it. Show you something that flew off. This flew out of here. I just dropped a little screen like about 2 months ago. And that's when it started leaking more. The good thing it did, because the water would go back here. See how this black mold grows there? It's very humid here. And when this water was coming out hot, it was even more humid. That's my wire brush. I use it to scrub behind here for the black mold to get under there. And see, sometimes I scrub this green stuff that builds up there. It's really hard. So I don't know what they're doing today, with no hot water, so I can't take a shower. I don't know how long this is going to go on. We're never notified here. They just do what they please when they please. They still haven't talked to me about the 2 leaks from the ceiling in the bathroom, different times, different dates. They were supposed to paint the apartment some time ago because of the water leaks in the kitchen. 2 different times, different dates. There's no window, just an exhaust fan, and the water bleeds up. Well, look at this. The ceiling is leaking again. And I want to call the building manager. But anytime I complain about anything, they get really angry. When put on some.
That's just showing how I can't, if I even try walking around.
Well, I don't know what those people upstairs are doing.